Welcome to our workshop, The Founding of the United States and the Structure of U.S. Government. This workshop is designed to cover the basics that you need to know for the Florida Civic Literacy Exam, or FCLE. There is a lot of material, so we will cover what we can, but this workshop is not meant to cover every concept you might find on the exam. This workshop is property of Florida Atlantic University, and it is illegal for anyone to use these workshop recordings or materials for financial gain. Over the next hour or so, we will discuss a lot of material. Feel free to pause the video, take breaks, skip portions you already know, and rewatch portions that you need to focus on more. Please note that the developers of this workshop, myself, Dr. Jennifer Biebergal, and Ms. Jeannie Takeda, are not historians or political science faculty. We learned this material in order to help you. All information is accurate at the time of this recording in the spring of 2025. So what is the FCLE and the civic literacy requirement in Florida? All students at Florida public colleges and universities are required to demonstrate competency in civic literacy in order to graduate. The FCLE is a multiple choice exam. You must earn 60% or better in order to satisfy this component of your graduation requirement. If you are unsure of the requirements related to civic literacy that you need to earn your degree in the state of Florida, please check with your academic advisor. We will start off discussing some of the concepts that were the building blocks for the United States. Please note that questions related to this material may be asked in a variety of ways on the exam. I will share some examples of that as we go over the content. We will start with concepts and principles that helped form the building blocks of the United States government. How many of the concepts you see here do you already know? Take a minute to review these terms and see if you can define them or at least jot down anything you may already know. While we go over each of these concepts, what foundation do you already have that you might be able to use to connect with the new ideas that you will learn today? On the Florida Civic Literacy Exam, you may be asked about concepts that can be found within our founding documents and where these ideas come from. The first set of ideas are known as Enlightenment ideas. You may be familiar with some of the concepts, but may not know the origin or how it is applied in the U.S. government. The Enlightenment is based on the ideas of equality and self-governance. One major concept in the Enlightenment is that people create government and they can change government. These governments are only there because the people allow it to be so. We see this in the idea of a social contract. This is the idea that there is an unwritten contract between the people and the government, that the people do the things that they are supposed to do, like paying taxes and obeying laws, and the government will do their job of protecting the rights of the people. This contract states that if government fails to protect these rights, the citizens can, for all intents and purposes, fire their government and establish a new one. This concept is what was used to seek independence from Great Britain. The people felt that the King of England was not protecting the citizens, so they broke with that government and created their own government in the newly formed United States. The belief was that the King of England didn't follow his end of the social contract. This concept is closely linked to the idea of consent of the governed. This says that government is only in place because we, the people, allow them to be there. This is also related to the idea of popular sovereignty, that government is created by the people and subject to the will of the people. On the Florida Civic Literacy Exam, you may be asked where we see the idea of consent of the governed or popular sovereignty in U.S. history. A couple of examples are in our founding documents. In the Declaration of Independence, you see the quote here: "Governments derive their powers from the consent of the governed." We see it again in the United States Constitution in its first three words, "We the people." This shows that it is the people that are creating the government and giving its consent for the government to be formed. The next Enlightenment idea is that of separation of powers. This is how government in the United States was created, with three branches that each have distinct powers, so no area could become too powerful itself. We will go into detail about the three branches of government and the powers that each has toward the end of this video. The idea of separation of powers is linked to the idea of limited government. When the country was founded, there was a fear of giving the federal government too much power, which could make it become like the government they just left under the rule of the King of England. Separation of powers was furthered by the idea of checks and balances. The ideas of separation of powers and checks and balances came from the founding father Montesquieu. We will see separation of powers and checks and balances in our founding documents. In Articles 1 through 3 of the U.S. Constitution, they create three distinctive branches of government with a variety of measures to have these branches providing some oversight over the others. Examples of this include that while the legislative branch creates laws, the president can sign or veto them. And while the executive branch appoints cabinet members and Supreme Court justices, Congress holds Senate confirmation hearings to approve or deny the appointees. We see this concept again in the 12th Amendment of the Constitution, where the president and vice president are elected, but Congress must count and certify the votes. The third and final major Enlightenment idea is that of natural rights. This is a main idea that John Locke brought to the Founding Fathers, taken from the English Bill of Rights. Natural rights say that all people are born with certain rights. In this case, the right to life, liberty, property, and religious freedom. We see examples of natural rights in several places in our founding documents. In the Declaration of Independence, we learn that all people are, quote, endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Unalienable rights means that they cannot be taken away, and endowed by their Creator means that the people are born with these rights. In the First Amendment, we see the right to freedom of religion, and in the Fifth Amendment, that no one can be deprived of their rights without due process. These are all considered natural rights. A key point to remember if you are asked on the civic literacy exam about an Enlightenment idea, that John Locke is the founding father that had the idea of natural rights, while the idea of separation of powers or checks and balances comes from Montesquieu. But the Enlightenment ideas are just some of the major concepts that you will find in our founding documents. Others include concepts such as the rule of law, which limits the power of government and individuals by stating that all people must follow the law. We see this concept in the U.S. Constitution. The Supreme Court confirmed this idea through the Supreme Court case, the United States versus Nixon, which found that although Nixon was president, he had to follow the law and provide documents that were ordered under subpoena. We'll go into detail on that case and the rule of law in the landmark Supreme Court case video. The idea that no one is above the law was not new when the founding documents were written in the United States. In fact, this concept dates back centuries. In 1215, when the Magna Carta was written, the concept that the king had to follow the law was the first known mention of rule of law. There are many references to due process in the founding of our country. Due process means that there are fair and consistent procedures that all must follow. The U.S. justice system is based on the concept of due process. It creates equity in how people are treated, particularly in criminal proceedings. In the Fifth Amendment, a due process clause sets up procedures that must be followed for all people charged with a crime. The federal aspect of this is extended to the state level through the 14th Amendment. Examples of due process include the rights for one to know why they are being charged and with the right to face their accusers. A key concept that students often confuse is the idea of federalism. Federalism is a balance between state and federal powers in government, and I'm certain you will see at least one question on the exam related to federalism. After the break from Great Britain, the colonists were afraid to create a governmental structure that gave too much power at the federal level. They didn't want to return to the type of structure that they had under the King of England. This led to the creation of the first Constitution of the U.S., called the Articles of Confederation. This provided a weak central government with most of the power at the state level to allow for more local control. But without a strong central government to unite the states, the country was unable to run effectively, and a new constitution was needed. As the new constitution was being drafted, anti-federalists called to keep strong state and weaker central governments. Federalists understood that they needed a strong central government to unite the states. A government that shared power between the state and national levels was the best way to ensure the rights of the people and that the country could run effectively. Later in this video, you'll learn about the Federalist Papers, a series of 85 papers written to convince the American people that a balanced government under federalism was necessary, and urging the people to ratify or pass the U.S. Constitution. The U.S. Constitution is based on this concept of federalism, or shared powers, and there is a balance of rights that belong to the states and those that belong to the federal government. On the exam, you may be asked questions such as, the following are all federal powers except, or which of the following are powers shared by both state and federal governments? So it's important to know these. The federal government has the power to print money, declare war, create an army, and make treaties. These powers should make sense. You wouldn't want each state printing their own money. Imagine traveling from state to state and your money might not be worth what you think it is. You wouldn't want states to be able to create armies or declare war or even create treaties or agreements with another country. Those are powers that should and do belong at the federal level. State powers include things that impact people locally, things such as providing for schooling and education, providing protection and safety through state and local police and fire departments, approving zoning and land use, and determining procedures and requirements for different types of state licensures. This is why some people go to Las Vegas to get married, as Nevada has simple requirements for a marriage license, whereas it may take days to get a license in another state. In some states, the driving age may be 16, while it might be 17 in other states. And why should the federal government be involved with decisions on how a parcel of land in Palm Beach County will be zoned for use, either as residential, commercial, or another purpose? That should be and is in the control of state and local government. There are only a few powers that both federal and state governments share, and those are the ability to collect taxes, build roads, and make laws. This is why we have state and federal taxes, state and federal highways, and state and federal laws. A little later, we will discuss the idea of powers explicitly given to the federal government in the Constitution versus implied powers, and how we know which powers belong to the state. There are many ideas and concepts embedded within our government. The next ideas center on individual liberties. These liberties or rights include religious freedom, equality, and limitations on government. Patrick Henry is known for the famous quote, "Give me liberty or give me death." Freedoms and rights of individuals are a central theme in the founding of the U.S. In the Declaration of Independence, you will again see this concept in the rights that we all have to life, liberty, and the pursuit of happiness. On the FCLE, you may be asked about representative government. Republicanism or democratic government are different than the Democratic or Republican parties you may be familiar with today. Republicanism simply means that there is a representative form of government, where citizens vote for representatives to handle the business of government on their behalf. This means that we, as individual citizens, may not directly vote on a law to be passed, but we are represented in that process by people that we do elect to represent us. Congress is our form of representative government. We elect members to the House of Representatives, see, it's even in their name, and they create laws and vote on our behalf. We don't have every citizen voting on every law, just those who represent our voices and ideals. Originally, the other branch of Congress, the Senate, was not representative, as senators were not directly elected by the people. But for the last 100 plus years, the people directly do elect senators as their representative voice in government. When these representatives are elected, it is expected that they will follow the will of the people who elected them. These ideas come from ancient times, such as in ancient Rome, when people elected magistrates who chose senators. The Roman people were not going to run government as a whole. They elected people to do that work on their behalf. Just a couple of more concepts that we need to define as we discuss the founding of the United States, and then we can take a break. Next, we have constitutionalism, or the idea that a set of laws or a constitution determines the role of government and prevents the government from acting inappropriately for their role. It also says the Constitution is the supreme law of the land, which we'll discuss further during the Supreme Court case Marbury versus Madison in the landmark Supreme Court video. The idea of supreme law of the land means that once whatever the Constitution says is the law, and nothing can override that. The idea of majority rule and minority rights is a foundational aspect of our democracy. For example, in Article 5 of the Constitution, it specifies what is needed to amend or make changes to the Constitution. It requires a minimum 2/3 vote, not a simple majority, just to ensure that people can then further vote on that change. We want to make sure this is a change that benefits a wide range of people. The First Amendment provides ways for a minority to be able to speak out against the majority, whether that is through protected speech, the ability to publish their ideas, or their right to petition the government without worrying about consequences. And many of the protections for minority groups are found within the amendments. Again, the First Amendment protects those practicing their religious beliefs. The 13th Amendment protected those who were slaves. And the 15th Amendment banned discrimination in voting, which was a concern for minority populations. These concepts tie to equality and equal protection under the law. We see these ideas in the Declaration of Independence, which states all men are created equal, although at that time it was not all people, just white men. We also see it in the 14th Amendment, which is based on equal protection, and the 5th Amendment, which has a due process clause to ensure equal protection. While founding documents and their amendments call for this equal protection, it is not always followed in practice. This has led to legislative and executive acts to be passed to further protect those rights. We will go into depth to these acts during the workshop recording on landmark Supreme Court cases, landmark legislation, and landmark executive acts. Last slide before a break. The final major concept that the foundation of the development of this new country is set upon is the idea of free, fair, and secure elections. This is essential for democracy. The idea of electing representatives with fair elections dates back to ancient times when both Greek and Roman governments had men elect individuals to serve as their voice in government. You probably have heard the phrase, one person, one vote. This means that in a fair and secure election, each individual gets a vote and only one vote, with each vote counting equally. A person's socioeconomic or political status should not impact the weight of their vote. This concept also ensures that people are not prevented from voting. We'll see this in several of the amendments that we'll cover a little later, and that the results are counted in a fair, equitable, and proper way. We'll see this in the landmark Supreme Court case, Bush versus Gore, in the other workshop. Wow, that was a lot of information. I encourage you to take a break, review the notes you took, or go back and watch any concepts you are still unsure about. Pause the video, and when you are ready to move on, we will cover the colonies and the colonies seeking independence from Great Britain. See you soon. Welcome back. In this section, we will briefly cover the colonies and why the colonists came to the new land. We'll talk about life under British rule and what led to the colonists seeking their independence. We will discuss an important pamphlet, Common Sense, which outlined the reasons to seek independence and what resulted in terms of a formal proclamation of independence by the colonists and the war that ensued. Ready? Let's dive right in. First, you should be familiar with the 13 colonies. If you're familiar with the United States geography, it makes sense that all the colonies were on the eastern coast of the United States as the colonists came across the Atlantic Ocean and settled close to the waterways. When you're trying to remember which colonies existed, remember there were 3 new colonies, New York, New Jersey, and New Hampshire, 2 Carolinas, North and South Carolina, and only 1 state with a V, Virginia. So on the FCLE, if you are asked a question, all of the following were colonies except, if you see Vermont, you know that that's not a colony because only Virginia had a V. Or if a state like Texas is on there, you know it's not on the East Coast. Florida was not an original colony either. Florida had already been settled by Spaniards when the colonists arrived. But why did the colonists come to America in the first place? At the time, Great Britain followed strict religious beliefs, feeling that uniformity of religion was essential in society. Majority religious groups would persecute those who did not follow their religious beliefs. Colonists came to North America seeking religious freedom to worship as they deemed fit. We will see how important this concept became in the New World as the First Amendment highlights religious freedoms. In addition to escaping persecution based on religious belief, many left for political freedoms. Some came as indentured servants. Some were even sent to the Americas as punishment. The greatest reason that people left Great Britain for the New World was seeking economic opportunity. This New World afforded people cheap land and opportunities to sell goods as merchants. So now we know why they came to the colonies, but why did they want to separate from Britain and declare independence? Once the colonists arrived in the New World, they were still under British rule, having to follow laws and pay taxes without having a voice in their government. Decisions were made, quote, back home that impacted them. The colonists believed that they should be able to set up their own government with their own laws, collecting their own taxes to meet their needs, not the needs of individuals an ocean away. Additionally, Britain sought to protect its land in the New World, so they sent soldiers, and colonists were forced to house and feed the British Army in their homes, even in times of peace. To make sure this didn't happen again, we will see that there is a constitutional amendment, the Third Amendment, which prohibits the quartering of soldiers or making people house and feed soldiers, known as quartering. As some colonists sought freedom from England, others needed convincing to part ways with their home country. In 1775, Thomas Paine created a 47-page pamphlet called Common Sense. This pamphlet called for the colonies to break from British rule. It was written in clear language, explaining the ideas of natural rights. Remember, everyone is born with rights to life, property, liberty, and the pursuit of happiness, as well as issues related to being ruled under the King of England and the need for self-governance. It is likely you will be asked about common sense on the exam, as it was a main factor that led to the uniting of colonists on the idea of independence and signing of the Declaration of Independence just 6 months later on July 4th, 1776. And soon we will talk about another set of writings, the Federalist Papers, and you'll need to be sure you can distinguish between Common Sense by Thomas Paine that led to the signing of the Declaration of Independence and the Federalist Papers that led to the ratification of the U.S. Constitution. So now we come to the actual Declaration of Independence. Again, this was signed on July 4th, 1776, which is why we celebrate Independence Day on the 4th of July. At the time, Philadelphia was a main political center of the colonies. 56 men came together and signed this document. Thomas Jefferson was the primary author, and if you have ever heard the term, "give me your John Hancock" when requesting a signature, that is because John Hancock was a founding father with the largest signature on the document. Remember we spoke earlier about that social contract, the idea that people create government and create a new government if they disagree with the ideas of an existing one? So in order to get a voice in government and avoid the issue of taxation without representation that the colonists faced, to end the quartering of soldiers, and to resume trade that the British had cut off, the colonists united in their desire to break from the old world. You may be asked on the exam about the components of the Declaration of Independence. This document has 4 parts. First is the preamble, which is like an introduction, telling the world that they're separating from Britain. Second comes the philosophy statement. This is where you may find some familiar language, such as, "We hold these truths to be self-evident, that all men are created equal, with unalienable rights to life, liberty, and the pursuit of happiness, and that these are natural rights, ones that are born with and are given by their Creator." The philosophy statement also declares the social contract that the people are giving their permission to form this new government. The third part lists the colonist complaints about the British government. And the final part is the conclusion, where they formally declare independence as a free and independent set of states with rights such as the power to go to war, seek alliances, and establish commerce and trade. Great! We have made it over 150 years, only a couple hundred more to go. So feel free to take a break, stretch, get some water, maybe a restroom break. When you're refreshed, join me as we learn about how the former colonists set up their new government with a constitution and then added to the constitution with amendments. See you soon. Welcome back. In this section, we will cover what happened before the Constitution and review some key elements that form the basis of the Constitution. 2 major conflicting thoughts on how government should be structured, the development of the Constitution and what it contains, and finally, the amendments to the Constitution. This section has the most content, so if you need to take a break at any point, feel free to pause the video and take that break. Here we go. The FCLE study guide advises being prepared to know where the ideas that are essential in the founding of our nation came from. We were not the first country to come up with these concepts. And these ideas go back centuries. In ancient times, the Greeks established the concept of democracy, with rule by the people and people having a voice in how their government functioned. While the ancient Greeks had many governmental structures over time, democracy, or rule by the people, at least the male citizens, was the concept that the colonists sought when forming a new government. In fact, the root of the word democracy, demos, comes from Greek, and demokratia is a Greek word. The concept was also taken on in ancient Rome. After years under the rule of a king, the Roman people wanted to safeguard citizens against the rule of one individual. They had the concept of elected magistrates and a senate to advise. From ancient Rome and ancient Greece, we move to the 13th century when England was under the rule of a king, but the barons and other nobles revolted, demanding that the king must follow the law. This was the first known reference to the concept rule of law. They also demanded rights such as rights of due process. Fast forward a few centuries as the Pilgrims came to the New World and set up rules for their self-governance. While they did not follow the concept of freedom of religion, they did have the idea of consent of the governed. The people were setting up the structure. Soon after, back in England, an English Bill of Rights was created, drawing on some of the ancient concepts including rule of law, the king was not above the law, and establishing rights and freedoms that we see mirrored in many of the U.S. founding documents. Free speech and freedom of religion became the First Amendment in the United States. The right to bear arms became the Second Amendment. And the ideas of aspects such as fair trials and no cruel, unusual punishment is found in the Fifth Amendment. In 1780, soon after the colonies declared their independence from England, John Adams drafted a state constitution for the state of Massachusetts. This still stands as amended in the state of Massachusetts today and became a model for the U.S. Constitution just a few years later. The Constitution in Massachusetts included elected officials and a system of checks and balances. After becoming independent, the country needed documents to guide its new government. The Articles of Confederation outlined this new government in what is considered the first constitution of the New World. This document gave far too much control at the state level and severely limited federal powers. You can see on the screen some of the elements that were missing from what we now know as the U.S. Constitution. The Articles of Confederation had minimal representation with only one member per state, which gave very little voice to those, especially in the largest populated areas. And the major issue was that the central government had insufficient powers. There was no executive branch to enforce laws, no national court system to interpret laws, limited power to regulate commerce, an inability to tax citizens, inability to create an army without state approval, which made defense difficult, and the inability to settle disputes between states, such as issues related to territory, taxation, or trade. At the Constitutional Convention in 1787, which was a meeting of the Founding Fathers, the delegates from each state agreed that the Articles of Confederation was not working and they should simply scrap it and start over. We'll talk about the newly proposed Constitution in a moment, but first you need to know about Federalists and Anti-Federalists. Earlier, we talked about the concept of federalism, or a government that balanced powers between state and national levels. But still, we had anti-federalists who feared that giving too much power to the federal government would provide opportunities for central government to rule harshly, like they had experienced under kings where they had just left. Anti-federalists sought for the government power to lie mostly at the state level. To convince the populace that they should adopt or approve or ratify the new U.S. Constitution, 3 of our founding fathers wrote a series of essays. Known as the Federalist Papers, these 85 essays were written in just 7 months. On the civic literacy exam, be sure you know the difference between those writings I mentioned earlier, Common Sense by Thomas Paine, written to get the colonists to declare independence, and the Federalist Papers that were written under the pen name or fake name, but really written by Alexander Hamilton, John Jay, and James Madison to convince the public why the Constitution should be ratified. In preparing this workshop, I didn't really know about the specific papers within those 85 essays, but the study guide highlights the 5 papers that you see here. I'm not sure how they might ask questions about these on the exam. However, you may want to at least know the basic concepts that the Founding Fathers used to convince the people. I'll pause for a moment so you can read what's on the screen. While Alexander Hamilton, John Jay, and James Madison wrote the Federalist Papers to support the ratification of the Constitution, Anti-Federalist Papers were written arguing against ratification. The Anti-Federalist Papers highlighted the things that I shared that the former colonists were worried about, that federal government would be too powerful, they would rule from far away, maybe not as far as the rule from England, but still could be 1,000 miles away from their state, and that would leave people with little influence. They also feared the document did not do enough to equally protect the natural rights of individuals. So here we are. What was in the U.S. Constitution? Many of the concepts you see here are things that we've spoken about already. The Constitution was to become the law, or the supreme law of the land, with a representative democracy. that listed fundamental rights for all, and a Bill of Rights that would protect those rights was added soon after the passing of the Constitution. The concept of self-governance or popular sovereignty is found in the first three words of the U.S. Constitution, "We the people." And remember, who was the one who came up with the idea of self-governance? That came from Montesquieu. And of course, rule of law. As John Adams wrote, our country is a government of laws and not of men. You may be asked about the structure of the Constitution. The Constitution has a preamble and 7 sections called articles. The amendments were added that are considered part of the Constitution, but not at the time of the ratification of the Constitution. The preamble has language you may be familiar with. We the people, meaning the citizens, authorize this document to establish government. The first 3 articles define the 3 branches of government, which we will cover later. 1 is the legislative branch, 2 the executive branch, and 3rd article covers the judicial branches. Article 4 deals with the relationship between the states and federal government. Article 5 deals with how amendments or changes to the Constitution can be made. Article 6 deals with federal supremacy, meaning states have their own laws, but federal laws, those in the Constitution, override state law. The Constitution is, say it with me, the supreme law of the land. And finally, Article 7 described how the Constitution would become that law of the land. It needed to be ratified by 9 of the 13 states. We've discussed many concepts in the Constitution already. Here are some more important ones. In Article 1, you can find the concept of enumerated powers. These are powers explicitly given to the federal government in the Constitution. Anything that is not explicitly stated as a federal power is one of 2 things. Either it's an implied power, meaning it isn't clearly stated, but it's implied that the federal government has that power in order to do the things the Constitution says it must do, or it is automatically a power of the states. Powers that will belong to the state are considered reserved powers. By giving states these reserved powers, it helps keep that balance of power and protect state rights, something many of our founders were very concerned about, that concept of federalism. In the FCLE workshop on landmark Supreme Court cases, we will discuss a case called McCulloch versus Maryland, where the court ruled that although the Constitution does not explicitly say that operating a national bank is a power of the federal government, it is implied and necessary and proper in order for the U.S. government to carry out its explicit duties of printing money and collecting taxes. So if something is not an explicit power in the Constitution, it can still be implicit as it is necessary and proper for the government. The necessary and proper clause is also referred to as the elastic clause, as there is a little bit of stretch and ability to decide where those powers lie. On the exam, you may be asked questions about which powers belong to the federal or state levels. It may be written such as, all of these powers belong to the federal government except, or the opposite, these powers belong to the states except. Earlier in this video, we discussed that the U.S. Constitution is based on the concept of federalism or shared powers, and that there's a balance of powers and rights that belong to the states and those that belong to the federal government. Remember, the federal government has the power to print money, declare war, create an army, and make treaties. We said that those make sense, as you wouldn't want each state printing its own money or creating armies, declaring war, and signing treaties. The state powers, remember, included things that impact people locally, such as providing for school and education, protection and safety through state and local police and fire departments, approving zoning and land use, and determining procedures and requirements for licensures, such as marriage licenses, driving licenses, fishing and hunting licenses, etc. And be sure to remember the 3 powers that both federal and state governments share: the ability to collect taxes, build roads, and make laws. I added this slide here to clearly show the powers of the state versus federal government. Feel free to screenshot this if you feel it will be helpful as a reminder while you are studying. We've already mentioned the Supremacy Clause several times. That is, that the state constitution is the supreme law of the land. But the Constitution has many other clauses. The Full Faith and Credit Clause says that a state court must respect laws and judgments of other states. It is known as horizontal federalism, as it takes the states which are on the same level and shows that decisions of one can bind another state. We briefly mentioned the Commerce Clause, which states that Congress can regulate commerce and economic activities that cross state lines. Commerce within a state can be retained as a state power. However, if it crosses state borders or, of course, international borders, Congress can regulate it. And the Emoluments Clause, which I hadn't heard of before putting this presentation together, states that Congress cannot change the president's compensation, for the current president, that is. This prevents legislative bodies from influencing the president based on threats to lower their salary if the president doesn't do what Congress wants, or bribing to increase the executive leader's salary. We have spoken about the due process and elastic clauses. Remember, due process protects individuals, saying there are certain things that must be followed to guarantee that citizens will not be treated unfairly or differently than others. We see this protection furthered through both the 5th and 14th Amendments that we are just about to get to. Again, due process provides equal protection, which is also reinforced through the 14th Amendment. And we discussed the Elastic Clause, which states federal government has the right to powers that are not explicitly stated in the Constitution, but are necessary and proper for the federal government to conduct its explicitly stated powers. Are you still with me? We are more than halfway through. The last two sections cover the amendments. There are 27 of them to know, and the 3 branches of government. Pause the video, take a break, and come back when you're ready to dive in. Welcome back. As we begin to discuss the amendments, you may be asked on the civic literacy exam how the Constitution can be changed or amended. As the Constitution is the supreme law of the land, the framing fathers did not want to make it easy to change in order to create stability and prevent a few in power from making significant changes. The U.S. Constitution has only been successfully amended 27 times. 10 of those, the Bill of Rights, were amended in 1791, just 2 years after ratification of the Constitution. 6 amendments have been proposed through Congress that were not successfully ratified. So 27 of the 33 total amendments proposed by Congress have been ratified. How does it work? As I said, it's not easy. Both houses of Congress, the House of Representatives and the Senate, must have a 2/3 vote on the proposal. Remember, we spoke about having more than majority to protect those in a minority? Once 2/3 of the Senate and 2/3 of the House approve the proposal, it goes to the state, and 3/4, currently 38 out of 50 of the states, must approve it. This is how 26 of the 27 amendments were passed. The 21st Amendment, which we will soon discuss, was a repeal of prohibition. This was passed by Congress, directing the states to call constitutional convention for the purpose of ratifying the amendment. This is the only amendment that was done in a different way. Only other way, which has not been done before to amend the Constitution, is for 2/3 of the states, which is currently 34 out of 50 states, to petition Congress for approval and then call a special convention. Then 38 states, or 3/4 of the states, must approve the amendment for it to pass. So let's jump into the amendments. The first 10 amendments are called the Bill of Rights. They were based on the Virginia Declaration of Rights about 15 years before. It expressed basic human rights that government was created to protect. Many of you may already be familiar with some aspects of the First Amendment. The First Amendment protects individuals' abilities to express themselves, protections for written and oral speech, the right to peacefully assemble, and the right to petition or speak out against the government was ensured. In addition, the First Amendment includes the Free Exercise Clause. This is the right to practice any religious belief or to practice no religion at all. It also states that the U.S. cannot have an official religion. Remember, the basis of this was the experience that colonists broke from under British rule, where people were persecuted based on religious beliefs. The civic literacy exam is likely to have several questions related to the First Amendment. This may include the 6 landmark Supreme Court cases that deal with freedom of expression covered in the other workshop recording. The exam may also ask about clauses that are part of the First Amendment. 2 are related to religion, that the U.S. government cannot establish a national religion, known as the Establishment Clause, and the Free Exercise Clause, which protects individuals to practice any religion or express any religious beliefs. There are 2 clauses directly related to words: free speech, which can be spoken or written, and a free press. And the last 2 First Amendment clauses allow for redress of concerns. This might be assembling peacefully in protest or petitioning the government without fear of retaliation. The First Amendment includes the most concepts you need to know. We can get through the others, hopefully a little more quickly. You may be familiar with the Second Amendment, the right to bear arms. Debate has circled about what was meant by the Founding Fathers with this amendment. Is it for protection? Can or should there be limitations and restrictions? With strong opinions on both sides of the issue, the meaning of this amendment is still questioned today. And again, there are 2 landmark Supreme Court cases that you should learn related to this amendment. The Third Amendment prohibits the government to require the quartering of soldiers by citizens. Remember, this is one of the major grievances colonists had that led them to declare their independence. If you have trouble remembering this one, remember, your quarters is another way to say where someone may live. And you can think of it as a 3-bedroom house, so quartering is a Third Amendment. Hopefully, that's a little trick that might help you. Throughout the workshops, I have some little tips that hopefully will cause you to remember some of these ideas, as there is so much content to cover. The Fourth Amendment sets out requirements for searches and prohibits unreasonable searches and seizures. This is why a police officer may not be able to look into the area of your car that isn't in plain sight unless there's probable cause. The landmark Supreme Court case, Mapp versus Ohio, deals with the Fourth Amendment. And I have mentioned the Fifth Amendment several times already in this video. This amendment provides protections related to due process. This is particularly related to how individuals must be treated in criminal matters, that they cannot be held without charges being filed, they do not have to say anything that can incriminate themselves, and that if they are found not guilty of a crime, they cannot be retried for the same crime, known as double jeopardy. The case Miranda versus Arizona deals with the Fifth Amendment, that someone must be informed of their rights when they are arrested. This amendment also addresses what is called eminent domain. This means the government cannot take private property without fair compensation. For example, when the country was expanding west, perhaps there was someone's land right in the middle of where a railroad was going to be built. The government cannot simply build on that land. They would have to offer fair and just compensation to the landowner. The Sixth Amendment states that individuals in criminal matters must be informed about what they're charged with and the ability to confront the person who has accused them and obtain witnesses in their defense. It also outlines rights to a fair and speedy trial by a jury of peers and the right to be represented by an attorney. The Supreme Court case Gideon versus Wainwright confirmed that if someone cannot afford an attorney, one would be provided for them at the expense of the state or federal government, depending on the level of charges. This led to the creation of public defenders, who are attorneys who can be assigned if someone is unable to secure counsel on their own. The Seventh Amendment similarly has protections, however, in non-criminal or civil cases. The Eighth Amendment prevents people getting excessive fines that don't align with crime and prohibits excessive bail requirements. For example, if you are caught recording a video during a concert and they tell you you have to stop and then gave you a $10,000 penalty for recording even though you never published it, that might be considered to be excessive. However, if you recorded the video and then posted it online and got compensated monetarily for it, then maybe that $10,000 fine is appropriate. We've spoken about explicit and implicit elements of the Constitution. The Ninth Amendment protects rights that are not specifically outlined. And the final amendment in the Bill of Rights, the 10th Amendment, protects federalism. Again, that sharing of powers that the federal government only has the powers that are stated in the Constitution or related to the work that is stated in the Constitution. Now we move on to the amendments that came individually. Remember, the Bill of Rights, the first 10 amendments, were all passed simultaneously in 1791. It's unlikely you'll be asked about the 11th Amendment, which established that federal courts don't have the authority to hear cases brought by private parties against a state where they are not residing. The 12th Amendment changed how the president and vice president are elected. This came about when John Adams ran against Thomas Jefferson. Both had very different political views. At the time, the person with the most votes would become president, and the one who came in second became vice president. Imagine the challenge of trying to get work done when the two top executives had such sharply contrasting views. Imagine in modern times if Kamala Harris became vice president as the runner-up to Donald Trump. It would certainly be a challenge for things to get done in government. So the 12th Amendment said that the president and vice president are elected together on one ticket. Now we'll jump ahead about 50 years until the next amendments were ratified or passed. This was right after the Civil War, and amendments came about to address post-slavery issues. The 13th Amendment formally abolished slavery within the Constitution. Abolishment of slavery was now the supreme law of the land. However, simply saying slavery was over did not create equal opportunities for those formerly enslaved individuals. The 14th Amendment defined citizenship, that former slaves now were citizens. The Supreme Court case Dred Scott versus Sanford, which happened before the Civil War, said that slaves were not citizens. With the 14th Amendment, not only are they now citizens, but they would receive equal protection under the law. There are actually at least 8 landmark Supreme Court cases that you should know that deal with the 14th Amendment and equal protection. If you haven't already, you should review my other workshop video on the landmark cases and acts. And we had the 5th Amendment protection related to due process. This was expanded in this amendment, the 14th Amendment, to the states, that no state could deprive citizens of their natural rights. While this amendment was written specifically to address former slaves, it has been extended beyond race to incorporate equal protection based on gender, ability, age, and more. Tied to the ending of slavery and establishment of protections for former slaves, the 15th Amendment prohibited the denial of the right to vote based on race. There are 4 of the 27 amendments related to voting. We'll summarize them together at the end of this section. I haven't seen a question related to the 16th Amendment, but it deals with Congress's ability to collect federal income tax. The 17th Amendment deals with how U.S. senators are elected. I had mentioned earlier that representatives in Congress had been directly elected by the people. However, Article 1 of the Constitution originally had the senators elected by state legislators. This amendment changed to U.S. senators, so they were directly elected by those they represent. While there were 27 amendments, only 26 are still in effect today. The 18th Amendment is the only one that has been repealed. This amendment, known as Prohibition, banned the production and sale of alcohol in the United States. Later, the 21st Amendment repealed or canceled this amendment. The 19th Amendment is our second amendment dealing with voting. In the 15th Amendment, there was no longer ability to deny someone the right to vote based on their race. The 19th Amendment prohibited denying someone the right to vote based on their sex, giving women now the right to vote. Note, this was ratified in 1920, just over 100 years ago. For the first 130 years of the United States, women were unable to vote. The 20th Amendment changes dates for terms of the executive and legislative branches. Every 4 years, a president is inaugurated on January 20th, and Congress begins its session each year on January 3rd. It also declares that the vice president will become president if the president-elect dies or cannot serve before they take office. We mentioned that the 21st Amendment removed or repealed the 18th Amendment of Prohibition. The production, transport, and sale of alcohol was no longer illegal in the U.S. with the passing of the 21st Amendment. A key way to remember this is because 21, people currently must be 21 to drink alcohol in the U.S., and the 21st Amendment is the one that allowed that to happen. A tip to remember the 22nd Amendment is 2-2. This amendment limited a president to serving 2 terms. The president can be elected no more than 2 times. And if they took office without being elected, if they were vice president, the president died, was assassinated, or otherwise left office, and they completed more than 2 years of that term, they could then only serve 1 additional term. So the 2 years of finishing another elected official's presidency and 1 more election for 2 complete terms. The 23rd Amendment gave the District of Columbia a say in federal elections. Prior to this, folks who lived in Washington, D.C. could not vote in the elections. The 24th Amendment is our 3rd voting-related amendment. While the other 3 all deal with who can vote or who cannot be denied to vote, this amendment prevents denying one's right to vote based on poll taxes. While rights to vote had been granted to a wide range of groups at this point, limitations in some areas were attempted by requiring people to pay a fee or tax in order to vote, or take a specific test, a literacy test, in order to vote. This amendment outlawed that, as it did not provide equal protection to all citizens. Okay, last 3 amendments. The 25th Amendment deals with what happens if the president dies or is no longer able to complete a term. This created the order of succession to go from the president to the vice president, and then the Speaker of the House of Representatives, and then next to the president pro tempore of the Senate. Why do you think the Speaker of the House is next in line after the vice president? I believe it's because that individual is directly elected by the people, where others in government may not be. This amendment also allows for the VP to serve in an acting capacity if the president is unable to serve for a brief period of time, such as due to a temporary health issue. Our last voting amendment is the 26th Amendment. This lowered the voting age to 18, again, expanding access to who could have a say in government. And our final amendment, number 27, prevents Congress from raising their own salaries. Any changes to compensation would go into effect following a future election to avoid conflict. Do you remember the 4 amendments related to voting? They're here on the screen. 15, 19, and 26 expanded rights to who could vote, including based on race, gender, and age. And the 24th Amendment took away barriers to voting. We're almost at the break. You may be asked how the Constitution and amendments have impacted civic participation. It is considered one's greatest civic responsibility to vote, so expanding voting rights expands civic participation. But the Constitution also created some limits on individual rights. In the landmark Supreme Court case Schenck versus United States, a right to individual free speech was limited as it could endanger national security. Schenck had tried to convince people not to join the military during wartime. You may already know that even though you have the right to free speech, you cannot shout fire in a crowded theater because it could endanger people. In Schenck versus United States, they found that telling people not to join the military during wartime had that same effect. Another limitation on rights can be found within the 4th Amendment. While it does protect the rights of individuals against unreasonable searches, it does allow for searches with appropriate warrants and in other circumstances. The Constitution addressed citizenship. Anyone born in the United States is automatically a U.S. citizen. This is called birthright citizenship. But this is not the only path to citizenship. The Constitution also outlines the process to become a naturalized citizen. In both cases, the individual has all rights and protections under the law. Some rights are for anyone in the United States, while some are only for citizens. You can see here which apply only to citizens, such as voting in federal elections, serving on federal juries, and running for federal office. But anyone living in the U.S., regardless of citizenship, has the right to protections within the Bill of Rights. This includes First Amendment rights to freedom of expression, freedom of religion, and ability to petition the government, and it includes Second Amendment right to bear arms. You may be asked on the civic literacy exam about participating in democracy. The question may be asked, Americans can participate in democracy in all of the following ways except. If this is how that question is asked, read the choices carefully and you may be able to just figure it out. Usually, they throw in an answer that doesn't really deal with democracy, such as volunteering at an animal shelter or at a food kitchen. It might be a nice thing to do, but isn't necessarily related to democracy. You see here on the screen several ways that you can participate in democracy. Which ones on this list have you done or would you like to do? I'll cover the last two slides before the break quickly. You may be asked about the U.S. economic system. Know that the United States has a capitalist or market economy. This simply means that individuals or corporations own most businesses, not the government. Business leaders decide what to produce and what to charge. Competition and supply and demand impact these markets. And I've listed a few key figures in U.S. history that you might want to know. I have seen exam questions such as, Benjamin Franklin did all of the following except. Did you know that Benjamin Franklin was a U.S. diplomat and a founding father who was a member of the Constitutional Convention? Did you know Franklin served as the first Postmaster General? Yes, we had U.S. mail over 225 years ago. And he also started the first free libraries. So every time you use a public library, thank Mr. Franklin. Okay, you have certainly earned a break. Pause the video, grab a drink or restroom break, and rejoin when you are ready to cover the last, smallest section of this workshop, the 3 branches of government. Welcome back. You'll be happy to know that we are near the end of the video with only 6 slides of content left. Remember, when the Founding Fathers were developing the structure for the federal government, they wanted to ensure that the central government, or an individual or small group of individuals, did not become too powerful. They created 3 separate branches of government that could each have checks on the other branches. To remember the role of each, remember executive branch, which includes president and cabinet, executive enforces the law. Congress creates, the 2 houses of the legislative branch create laws. And the judicial branch judges whether these laws follow the Constitution. Let's delve into each branch briefly, particularly with a look at how they interact and keep each other in check. Again, the executive branch is led by the president, but also includes the vice president and the cabinet. If you're watching this in 2025 when I'm recording the video, you may have followed Senate confirmation hearings for Trump's cabinet appointees. This is considered a check and balance. The president selects cabinet members while Congress decides if those cabinet nominees should be approved or rejected. Another presidential power is signing treaties and setting policies. And the president can propose or suggest laws to Congress, but Congress does not need to pass or even consider the proposal from the president. When there's an opening in the Supreme Court, the president nominates a replacement judge. Of course, Congress can still reject the nominee through Senate confirmation hearings. And the president has checks on Congress too. Once Congress signs a bill into law, it does not officially become law until the president decides to sign it. The president also has the opportunity to veto the law, meaning that it does not become law. And the final power of the executive branch we will cover is that the president presides over the military as commander-in-chief. However, while the president leads the U.S. military, the president does not have the power to declare war. This is an aspect of checks and balances, as only Congress can declare war. A few other important things to remember about the executive branch. We just covered the 22nd or 2-2 amendment, which states the president can only be elected to a maximum of 2 4-year terms. This passed after the only president ever to serve more than 2 terms. Does anyone remember who that is? Yes, Franklin Delano Roosevelt, or FDR, was the only president to serve 4 terms, and this amendment was ratified after that time. You should also know how the president is elected. The people do not directly elect the president. On the Tuesday after the first Monday in November, the election occurs every 4 years, and people cast their votes for president. But then there are electors from each state based on the size population of the state, and these electors actually cast official votes for president on behalf of the people they're representing in this capacity. Nearly all electors in the U.S. history have cast their votes in accordance with the popular vote from their state. There have, however, been a few instances where the electors did not vote for the candidate selected through the national election, but this has never impacted the overall outcomes of the presidential election. If you are asked a question on the exam, all of the following positions are directly elected by the people, except that exception is likely to be the president. You should also know what happens if a president cannot complete their term. This has happened 9 times in history. The 25th Amendment we just discussed outlines what happens if the president cannot complete their term. The vice president would automatically become president, but if both the president and vice president cannot serve, as I shared earlier, the Speaker of the House becomes president. And remember, the 12th Amendment changed how the president and vice president are elected, putting the candidates together on one ticket. The last things to know about the executive branch is related to the president's cabinet, which is kind of a presidential advisory board. When George Washington became the nation's first president, there were only 4 cabinet positions. If you've ever seen the play Hamilton, you may know who these cabinet members may have been. This included the Secretary of State, Thomas Jefferson, and the Secretary of the Treasury, Alexander Hamilton. They also had Secretary of War and an Attorney General, neither of which had a large role in the musical. Now, there are 16 cabinet positions, not just the 4 that we had originally. This includes the vice president, who is the only elected member of the cabinet. All others are selected or nominated by the president and then confirmed by Senate. The legislative branch is the United States Congress. It is considered bicameral, which means 2 houses. The prefix bi meaning 2, and the root cam meaning house. One house is the Senate, which allows each state 2 representatives. With 50 states, we currently have 100 senators. This gives each state an equal voice within Senate. Senators are elected to 6-year terms, the longest elected position in the branches of government, and they can be elected as many times as the people want, with no limit on how many terms they can serve. The other house is the House of Representatives. This house has 435 voting members. Each state has a differing number of representatives based on population. States with larger populations have more representatives. Every 10 years, there is a population census, which can change how many representatives an area may have. Unlike senators who are elected for 6-year terms, representatives are only elected for 2-year terms. This helps to ensure that when they go to Washington, they accurately represent the people in their districts. If they don't, the people may not re-elect them. This is a clear example of our representative government. Like in ancient Greece, we find people to make laws on our behalf. When putting together Article 1 of the Constitution and forming the legislative branch, there was dispute among the different colonies, becoming states, based on how they wanted to be represented. Colonies with the smallest population wanted equal representation by each state, which is now seen in the Senate, and the larger population states wanted to have more representatives, a larger voice for the larger population, which is what we have in the House of Representatives. There are also territories in the United States. These are not considered states, so each territory has 1 non-voting member in the House. And the Speaker of the House is an important role, as they are second in line of succession to the president after the vice president. We come to our final component of the workshop, our final branch, the judicial branch. This includes the Supreme Court and other federal courts. While Congress creates laws, and the executive branch enforces laws, the judicial branch judges whether things are in alignment with the law. Currently, there are 9 justices on the Supreme Court, and you should know the Chief Justice since 2005 is John Roberts Jr. This is accurate as of March 2025. Supreme Court justices are appointed for life or until they step down or are no longer able to serve. When there's a vacancy on the Supreme Court, the president has the authority to appoint a new justice who then must be confirmed by the Senate as part of checks and balances. You can learn a lot more about the types of issues that the Supreme Court has decided during the second Civic Literacy Preparation Workshop, Landmark Supreme Court Cases, Landmark Legislative and Executive Actions. I hope you found this video helpful as you prepare to take the Florida Civic Literacy exam. Feel free to go back and rewatch sections as needed. Once you feel confident about this material, I encourage you to watch the companion video that covers the remaining major things you should know for the exam. Thank you for watching, and best of luck.